Well, I can just start with you if that's all right. We talk about court intervention. What might that look like?
You know, probably Lynette would be the person to talk about
maybe
that.
Lynette could answer that a little
You want
better.
me to move all these?
Yeah.
Sure.
Yeah.
Well,
Thank you.
No,
Thank
just
you
move
for
mine.
doing that.
How's that? Is that close enough? And I'll just kind of swing this way a little bit.
Perfect.
Well, we've asked for a preliminary injunction, which is an expedited proceeding. Hopefully, we know our case is filed and the court will recognize it. We're already better off than a lot of people who filed with DHS. I apologize for being sarcastic, but the stories that Gretchen has told and heard are nightmarish. And you all read about one of them, you know, the person who found out that all of her children were listed as dead. You know, I mean, on top of everything else, that people are, you know, have to wait in line and get no service and go back again, and you know, with limited means to begin with. These are cutting into valuable efforts that they could otherwise make. We're asking for the court to restore the SNAP benefits for the two named individuals and for all others similarly situated. The exact parameters are not defined in our paperwork, but essentially it's our position that the state has to use all of its resources, including, if it's appropriate, to call back supervisors who have the institutional memory to do this work, use paper documents if that's what it takes, whatever is necessary to get people processed. And then they can spend the time on the state's time after hours getting things up to speed, whatever it takes. But it's clear that whatever they're doing so far, and I don't question their good intentions, nobody wanted to create this nightmare, but they keep thinking they've got it under control. They clearly do not have it under control, and there does not seem to be that you know, total commitment that is usually brought about by a court order directing that, you know, under penalties of contempt, this is what you must do. I mean, they've already received notices from the federal government that they've jeopardized continued participation in the program, which is just the opposite of what our clients are interested in. They want the benefits of the program, certainly don't want Rhode Island to lose its status as a participant because of these errors. So we're not committed to a specific course of action, but we believe that, you know, and to the extent necessary, if the state doesn't have a system that will accomplish getting these applications entered, processed within the time periods, then they have to use all types of processes, not just trying to stick with and correct the UHIP system, which is obviously not functioning correctly at this point.
Could the state has said that they're trying everything they can to fix the system to get things back on track? Could filing a lawsuit hamper their ability to focus on their job?
It's not been my experience that the attention and the focus of a lawsuit causes an agency, this type of a lawsuit. We don't think that this will distract the state to engage in a lot of discovery. I mean, the facts are pretty clear. You know, and everything that we're seeking to have them do, they're supposed to be doing now, to the extent that we're trying or will be trying to develop the fact that they've received applications and have not recorded them, and that their actual clearance rates are far worse than the horrible, I mean, the notion that approximately 50% of the applications that the state recognizes as qualifying for expedited are not processed within 7 days is a horrible number to begin with. But if Gretchen is correct, and I have, you know, and the facts seem to bear it out, that number is based on their most rosy date of when the applications have been received as opposed to the real date, it could be closer to 0%. People are waiting to get their benefits, and they're being told to engage in, go to food pantries, do something else, come back over and over and over again, and all of which detracts from their ability to take care of their families.
Is there a specific time frame or example or reason that made you say, we need to do something, one particular family that made you push to the limit of, we need to do something and let's file a lawsuit?
Well, I mean, the consideration of the lawsuit has been under consideration for some time, and it's a combination of several things. One is from, as Gretchen was saying, the effort is, if we can get people their benefits, the fastest way we can get them, that's what counts. And so Gretchen and Legal Services have been trying one person at a time to accomplish that. And when it becomes clear that is not going to take care of the problem, and the state also has projected that certain aspects of this problem, by its best estimates, are not going to be corrected until June, that's just not good enough, so we needed to proceed. And the specific timing also included identifying individuals who are willing to step forward, because that is a time commitment on their part and a publicity commitment, and and anybody who could get their benefits during the time that we've been speaking with people, they got their benefits and they're still resources for us, but they're not plaintiffs. So it was a combination of all those things coming together, and Steve would know more about that.
Do you feel like because these are all low-income and very low-income people that maybe, I hate to say this, but maybe the state is taking them less seriously than maybe another group of people, or that their needs aren't being acknowledged as much? Maybe they're not as able to be vocal about it?
As someone who litigates against government a lot, not particularly. I think that there's a huge commitment to this program. There's a lot of people within the system that work for the program, and there's a lot of federal money coming into the program. The state, unfortunately, seems to have had multiple bad outcomes with computer migrations. I mean, we know that on the DMV, there's a case going on now. That certainly is not just low income. Everyone, I think, who's ever dealt with the DMV is frustrated by that. There are, these things happen. I think the state is taking it seriously, but not sufficiently seriously to make the kind of commitment that we believe has to be the first priority. And we believe that the priority has to be stronger because of the needs of these individuals and the obligations of federal law.
Why not name Deloitte as part of this suit?
Well, our issue is on behalf of the individuals. The fact that the state selected a particular way to process that is a partial explanation as to why they're not in compliance. But it doesn't really matter to us whether they picked Deloitte or they did it another way. They have to comply with the law. It's unfortunate that the people that they picked may have contributed to the problem, and they may not have. I mean, at least from my reading of the materials that Gretchen amassed and are attached to her declaration, the federal government, the food stamp program nationally, it gave them a number of red flags explaining why it was risky and should not proceed with the kind of migration that they had in mind, that it was likely to produce this kind of outcome, that they were doing too much at once. And that's not a Deloitte problem, that's a state problem. They made the decision to do all these parts. Now, it could be that Deloitte was overconfident and told them that everything would be fine. But, the state is they're the administrators, the professionals, the ones with the responsibility, and they had the assistance of the federal government telling them, don't do it this way, it doesn't make sense.
The state's position is that this is on the scale of this system, that these problems are going to happen. They happen in other instances in other states. What would you say in response to their response/excuse?
If they know, as they should, anticipate that these kinds of problems are going to happen, and they know, as they should, that they have an obligation under their participation in the food stamp program to provide these benefits within 30 days to regular applicants and within 7 days to expedited, the most vulnerable applicants, then they need to set up the backup systems and the redundancies and the protections in advance to make sure that when those things happen, they have a fallback so that those errors don't impact the recipients. Clearly, they did not.
Susan was asking about Deloitte. As an attorney, if you were on the state side of it, should the state be suing Deloitte, as Massachusetts has multiple times?
It's hard enough representing my clients. I'm not going to give any advice to the state, who in this case is the adverse party. But I assume that they have those resources and they have people who can give them advice on that issue.
What's the timeline for all of this? When would an injunction happen? Just kind of, what are the specifics of that timeline?
Well, we filed the motion. We have not served the state yet with the motion or the lawsuit. We just filed it right before midnight last night, and we'll be getting in touch with them. We need to determine whether we need to get relief for the two named individuals on a super emergency basis. If so, we will be asking that it be brought in within the next couple days. If they're reinstated or provided benefits, we may have a few more days, but we need to engage with the state and the court, and some of that timing depends on the court. But this is a process that the state has not been able to fix overnight, but we need them to focus on everything that needs to be done. So generally speaking, having filed the motion, they have a set period of time to respond to it, and once we engage the state, we'll be asking that those periods of time, if necessary, be shortened so that the court can consider these issues and help us develop relief.
And this just concerns SNAP, right? You're not naming any other benefits that are processed through the system.
Right, because it is the SNAP program that, as a matter of federal law, has these very specific deadlines.
And obviously, just to clarify, once those two people in the lawsuit are served, it doesn't end there, I think is what you're getting at. So if you can talk about that.
Sure, this is a class action. We named two individuals, and they brought this action on behalf of themselves and all others similarly situated, which is described in the complaint, and I can find that reference. It's all Rhode Island residents who since January 1, 2016 have applied, are applying, or will apply for SNAP benefits through an initial application. The point of a class action is it's just the same thing that I observed before about legal services. It enables the litigant to go forward without having the individuals picked off one by one that we've restored your benefits, now there's no claim. The class action vehicle recognized that if the individual is recognized to be a proper class representative, and it is allowed to proceed as a class, then the fact that that individual gets their benefits before the case is over does not remove their status as a class representative nor eliminate the class action status. Classic cases of that sort had to do in the past with durational requirements to register as a voter. So if you had to be a resident for like a year or 6 months and you filed it on your own, eventually you'd age out, and so the cases would go away. You couldn't get them to move forward, because every time you move forward, somebody would finally satisfy the durational requirements. So the law and the courts have recognized that if you have the injury at the time you file the case, you don't have to have it at the time the court certifies the class to go forward with it.
Do you see any obstacles to getting the class certified? Do you?
Well, I mean, in our class action memorandum that's in support of our motion, we cite from around the country, and including Rhode Island, cases where class actions have been certified in these kinds of circumstances, federal benefits, food stamps, Medicare, and so forth.
And the only relief you're asking for is that they get their benefits if they're due them, no other...
I'm sorry, didn't mean to interrupt. We're also asking that due process be provided because people are not getting notice or hearings. So in theory, that also means that you know, our class representatives claim that they're eligible, but their eligibility hasn't been determined because they're not getting any notice or opportunity to be heard, and that's part of the claim as well.
What if they say that they can't process all of them because of problems with the system? How would they go about, or how would you want them to go about restoring the benefits if they say, well, these glitches aren't allowing us and we can't do it in the time that the lawsuit or is asking them to? That makes sense.
I mean, we don't accept that as a response. The federal government's not going to accept that as a response. They're getting 50% of their administrative costs to run the program and all of the costs to pay for the program from the federal government. Now, again, as I said, I don't represent the state. I don't know whether they can recover all of the additional and potentially extraordinary expenses they're going to incur because of the number of glitches and miscues and errors, and maybe that's where that other lawsuit comes in. But in the meantime, the state, has not devoted and all of its resources to fixing this problem. Nor do I believe at any stretch of the imagination that it would need to devote all of its resources to fix these problems. But it needs to devote more resources than it is now, and to the extent that it is determined to make the corrections only through making the UHIP program work. That may be, an incorrect thing to do. I certainly know nothing about it, but I know that before UHIP, they were administering this program. And when we sued them in 2009, it was over the same kind of issues. At that point, I believe their margins were about 15% off of 100%. These margins are 20% on the regular and 50% on the expedited, and that's giving them the benefit of the doubt that they're actually recording them on day one. They've done it before. That case ended with a consent order where we monitored them for, I think it was 18 months, to make sure that they got within a very small range of perfect. And there they remained until they decided to migrate to the system. So they had a decades-old system that worked. Maybe it didn't work as well as they wanted, maybe it was more expensive, maybe it was top-heavy on management, but it worked. And if that's what it takes, that they need to stop, roll back, go back to where they were, and then start over again, the people who are experiencing the negative outcomes of the system should not be the ones who are supposed to get the benefits. And that's our position.
In preparing for this lawsuit, did you have any conversations with FNS?
I did not. I don't know if you did.
I did have a few conversations with FNS and shared some information with them. I know they were also, like us, out at the offices going through the lines, so we saw them in that context as well. So I was in touch with them about the processing delays.
Any other questions?
Thank you so much.
Thank you for coming.
Thank you.